Merci, Madame la Présidente. This evening, my friends, I want to tell you the real story of a real Alberta woman. She was a 58-year-old wife and mother from the Red Deer region, and for years she had lived with untreatable pain. Involuntary muscle spasms radiated from her face and head into her shoulders. Her eyelids had spasmed shut, leaving her effectively blind. She suffered constant migraines. Her digestive system had all but shut down. She'd lost so much weight and muscle mass, she could no longer walk, and her pain was so unremitting, she could only sleep when heavily medicated. And so, with the support of her husband and her adult children, the woman, known as EF, petitioned the court for medical aid in dying. This was April of 2016, after the Supreme Court's Carter decision, but before the passage of the bill then known as C-14. An Alberta judge granted her petition. The Alberta government did not contest that ruling, but the federal government forced her into the Alberta Court of Appeal, arguing against allowing her to end her life. Now, you may wonder, why did the Trudeau government fight so hard to keep EF alive and in agony, especially after Carter? True, her death was not reasonably foreseeable, but that wasn't the Crown's primary concern. The government opposed her application because of the cause of her illness. She'd been diagnosed with a severe conversion disorder, a psychiatric condition in which the body responds to stress or trauma by exhibiting physical symptoms with no clear organic or neurologic cause. The Crown argued ER could not receive medical aid in dying because her physical torments had their origins in a psychiatric condition. But her sufferings were absolutely real, even if they had their genesis in her brain and not some less complicated organ. EF wasn't deemed clinically depressed. She wasn't delusional nor psychotic. Her doctors deemed her competent. But she was in unbearable torment, and none of your neurologists or psychiatrists or internists could cure her. The Alberta Court of Appeal agreed that she was entitled to all the rights laid out in Carter because, they said, persons with psychiatric illnesses were not explicitly nor inferentially excluded from access to MAID by the Supreme Court. The decision itself is clear, wrote Justices Peter Costigan, Marina Paperny, and Patricia Robotham. No words in it suggest otherwise. If the court had wanted it to be thus, they would have said so clearly and unequivocally. They did not. The judges continued. The court's decision was premised on competent individuals being entitled to make decisions for themselves in certain circumstances. The court recognized that there was a need to protect the vulnerable from abuse or error, but determined that a properly administered regime is capable of providing that protection. And so EF was able to slip away peacefully with her family around her. Her body, her choice, her freedom. Yet now we have Bill C-7, which specifically denies equal treatment under the law to those whose irremediable suffering is deemed to be solely due to mental illness. What is a mental illness? C-7 never deigns to define the term, and even after today's amendments, things are still murky. Does it include patients with Lewy body disease, someone with symptoms caused by an inoperable frontal lobe tumor or traumatic brain injury, someone with intractable hereditary schizophrenia? If we can pinpoint a cause, something we can see on a scan or diagnose with a test, is it still a mental illness? Or is it just, well, an illness? We're still captive to a 19th century paradigm which sees diseases of the mind as a kind of spiritual weakness. Even today, we discuss them as though they're something that can be cured by talk therapy or yoga, rather than something caused by a biochemical imbalance or brain insult or neurological malfunction. And while the amendments we've accepted today do improve the bill, I want to go on the record, inspired by Senator Wu, to underline my profound opposition to the mental health exclusion even after the amendments. Section 15 of the Charter says every individual has the right to equal protection and benefit of the law without discrimination based on mental or physical disability. But C-7 explicitly denies equality and autonomy to Canadians with certain particular illnesses because of archaic prejudice. It's established Canadian law that people with mental disorders who are judged competent have the right to make choices about their medical care. In 1991, in Fleming v. Reid, the Ontario Court of Appeal put it this way, quote, Mentally ill persons are not to be stigmatized because of the nature of their illness or disability, nor should they be treated as persons of lesser status or dignity. Their right to personal autonomy and self-determination is no less significant and entitled to no less protection than that of competent persons suffering from physical ailments. We surely can't reverse 30 years of legal precedent now. The unreasonable discrimination of C-7 cannot be saved by Section 1 of the Charter. It fails the Supreme Court's own Oakes test on 3 counts. The Crown's goal in crafting this legislation is clearly pressing and substantial. But denying MAID to an enumerated class of Canadians based solely on an anachronistic misclassification of their medical condition is not rationally connected to the purpose of the law. It's an irrational perversion of the law's avowed goal. Nor does the exemption count as minimal impairment. It's the maximal impairment conceivable. Nor is the effect proportionate. Safeguards could and would be put in place to ensure that a patient was mentally competent, that they were not delusional, nor suffering from a treatable or temporary depression, nor under social or economic duress. Instead, without any effort to strike a balance or find reasonable accommodation, the Crown intended to deprive an entire class of Canadians of their security of the person simply because they claimed it's too hard to uphold their Carter and Charter rights. Not every person with a mental illness has the necessary capacity to make life and death decisions. Any psychiatric patient requesting medical aid in dying would need careful individual assessment. But mental illness is not an all-or-nothing category. As then Chief Justice Beverly McLaughlin put it in the landmark Starson case, mental illness, without more, does not remove capacity or autonomy. No one with clear capacity should have their autonomy automatically denied without recourse. Such discrimination is not saved by arguing that we are doing it to protect the vulnerable, that we have to act in their best interests because we, paternalistically, know best. Senator Gold told us in December that we must protect vulnerable persons from being induced, in his words, to, quote, commit suicide in a time of weakness. But MAID is the antithesis of suicide, nor are people weak because they no longer choose to bear the unbearable. The government representative has told us, quote, Bill C-7 is based upon the assumption that persons suffering from mental disorders can, in fact, improve, that their suffering, though intolerable in the present, may be alleviated in the future through treatment, and that their medical condition, though grievous, may not in fact be irremediable. But we can't hold suffering Canadians hostage because of the faint hope or the vain hope of some imagined therapy in some imagined future. There has been so much passionate, heartfelt debate here about protecting the vulnerable. But surely the most vulnerable people of all are those who are trapped in agony, asking to die with dignity. The very right Sue Rodriguez fought for out of bravery, not weakness, in 1993. I understand concerns that allowing MAID for people who are not terminally ill could send a message that the lives of those with disabilities are deemed not worth living. But we should all support the principle of autonomy. No one, especially a person with a disability, should want to live in a world where the state can assert control over our bodies or discriminate on the basis of disability. We must respect the capacity and liberty of all Canadians. We must do more to ensure authentic autonomy to those living with disabilities, ensuring their right to proper economic, social, and medical resources. And at the same time, we must respect the decisions of competent people who determine of their own free will, without coercion, overt or subtle, that their suffering is unbearable to them. These two goals need not be antithetical. They are both grounded in our shared belief in personal liberty and the right to self-determination. Our bodies and our minds belong to us, not to the Crown. If we cannot be sovereign over our own lives and our own souls, then we are enslaved indeed. Thank you. Merci. Hi, hi.